Hi, this is John Goodman recording the third, not the second, not the fourth, but the third video in our series of videos about COVID-19. So what this one is about is in response to the demand in the real estate brokerage community for a COVID-19 clause. And the kind of clauses that I perceive that most brokers are looking for are clauses that would allow their client and perhaps the other side allow the buyer or the seller to get out of the contract should there be some consequence from COVID-19 that would make it, if not impossible, for that party to follow through on the transaction, to close on the transaction. If not impossible to perform, at least make it extremely difficult, inconvenient, extremely difficult to close. So, what this video is about is explaining the issues that come up in these clauses. I am not recording this video with the intention that somebody watch it and go, okay, now I know everything I need to know to write such a clause, and I am going to sit down and take down I'm going to use everything that John just told me to write a clause. That is not what this video is about. That is not what this video is about. In a later video, I will give you some more specific ideas for clauses. In the later two videos, I will do that. But what this clause is about is it's designed to put something on the web that is designed for anybody who is a stakeholder in such a transaction, the buyer, the seller, the listing broker, or the selling broker, to have an understanding of how phenomenally complicated it could be to write a good clause. So here are some of the issues that are involved in writing such a clause that would excuse a party in the event there is a COVID-19 related consequence. So the first issue is, what are the risks we're trying to manage? For example, are we trying to manage the risk that the title companies are not open to close the transaction? Are we trying to manage the risk that the clerk and recorder's office is not open and we can't record the documents? Are we trying to manage the health risks for the participants? Are we trying to manage the risk that even though the lender has given the clear to close on day 35 before closing, on day 39 before closing, or even on the day of the morning of the closing, day 40, the lender decides they've changed their mind, they're not going to fund the loan? Are we talking about a problem the seller has in evicting the tenant that the seller was supposed to, the tenant that the seller was supposed to evict in order to give possession of the property free and clear of that tenancy? Because as I record this, at least in the state of Colorado, the major municipalities and county offices have announced that sheriffs will not be spending any of their resources executing what we call writs of restitution to complete evictions. What about problems that with other deals and other deals that are dominoed based on this one? In other words, things could be just fine for the transaction you're closing, except that you're working with a buyer who needs to close on the sale of a property in Chicago in order to be able to fund this transaction. What if there are COVID-19 problems that affect the other transaction? We could go on and on and on, but that's the first issue. What are the contingencies? What are the events? What are the risks we're trying to protect against? Another question in drafting these clauses is which side are we trying to protect? Are we trying to protect the buyer? Are we trying to protect the seller? Are we trying to protect both? Now I know that most of you will say both, but each party in the transaction has their own specific needs, and then the way the Division of Real Estate's contracts works, is the buyer tends to have much more freedom to break a contract, because all the buyer has at stake essentially is their earnest money if it's a liquidated damages contract. A seller who chooses to breach the contract can be sued for damages, specific performance, or both, and have their title tied up for a long time. Another issue in drafting these contingencies are, what are the consequences of this anticipated event occurring? Is there an extension of time? Is that extension of time indefinite? Does it have a finite period of time? If the extension is for a specific amount of time, does the extension start clicking? Let's say it's 10 days from when one party gives notice of the concerning event occurring, or does it extend things beyond the already scheduled dates? In other words, are we talking about 10 days from notice or 10 days from the scheduled closing date and the scheduled loan termination deadline? I have seen some contingencies that purport to have the extension apply until the resolution of the concerning event. So for example, if the reason the closing got extended was because the clerk and recorder's office was not open or not available to accept recorded documents, then the extension of 10 days only starts, the 10 days only start until the clerk and recorder's office reopens for business. How are the consequences triggered? Is it automatically occur? Does one party have to give notice to the other? Could either side provide notice? So those are just examples of some of the complexities of addressing these issues. Remember what I said at the beginning. Do not say, oh, okay, I get it, and then try and address all those scenarios. No, don't do that. That's what lawyers are for. And even lawyers don't try and address all those things. Lawyers hopefully are informed by those concepts as they draft these sorts of contingencies. In the next version, in the next video that I will record, the fourth, I believe, in our series, I will give you more focused sort of advice about my approach, my suggested approach in protecting your buyers or your sellers from COVID-19 contractual risks. Thank you for listening this far. Remember, we live in a complex world and now one that's a little bit more dangerous, so be careful out there.